everyone, and welcome to Equality for Workers Unions podcast. I'm your guest host today, Sana Zahir, and I'm joined by Chelsea Brooke-Ward. She's an employment specialist barrister at Park Square Chambers. She has extensive experience in employment law and has represented clients in unfair dismissal matters, discrimination matters, and whistleblowing and breach of contract. Today we'll be speaking to Chelsea to gain her experience of working in this area of law and just to get a better understanding of what workers can do when they are representing themselves in tribunal or going through workplace issues. Thank you for joining us today, Chelsea.
Thank you for having me.
So Chelsea, what motivated your journey to the bar, in particular in employment law?
I didn't always want to be an employment barrister. I think employment law sort of found me. I've got a background in business, so I've got an understanding of what employers look for and the difficulties they face in terms of having staff to care for and running the business and all the costs associated with that. But I think employment law sort of found me, and my reason for becoming a lawyer was because I wanted to help people, and employment dictates quite a big part of our lives. I mean, we spend 90% of our time at work, and so if there are issues at work, that can affect the rest of our lives effectively. So I think employment law really matters and really makes a difference.
Before you came to the bar, you had your own business. Do you think being an employer influenced how you practice?
Yeah, I think it does, because it gives me that sort of dual understanding of being an employer and being in that situation and understanding how difficult and vast employment legislation is, and actually knowing what your obligations are is sometimes quite difficult. It's difficult for lawyers to understand the realms and realms of legislation and employment law. So as a very small business owner, I was out of my depth at times, and so I do have that level of empathy and understanding, and I can use that for both sides really, because I've been an employee in difficult employment situations, and I understand that the difference in bargaining power when you are an employee to an employer. There's that difference in control, in the sense of if you're an employee, somebody else has that power over you effectively, and you could stand for things in your employment situation that you wouldn't necessarily stand for in your personal life, because at the end of the day it pays your bills and keeps a roof over your head. So I think it does help, or it has helped. I'm just an ordinary girl, and people running businesses and employees, they're all ordinary people, so it gives me that sort of rapport with them.
Thank you. So Chelsea, a lot of employment disputes involve discrimination. From your experience, what are the main issues around discrimination in terms of workplace issues, and how can employers but also employees understand discrimination better?
I think the difficulty with discrimination and the misconception about discrimination is that it requires some type of motive or malintent, which isn't always necessary. And in fact, sometimes discrimination can be much more nuanced than overt discrimination. So, somebody calling somebody names or doing something on purpose in front of others. It's either culture-based disadvantages, or it's behind closed doors because nobody wants to put it in black and white, pen to paper, because they don't want to be held liable for it. So it's really difficult to prove, and the legislation with regards to discrimination is found in the Equality Act 2010, and there are a number of different ways that a person can be discriminated against, and each different prohibited conduct under the Equality Act has a different test. And I think sometimes people feel aggrieved by a certain act or omission carried out by their employer, but a feeling of unfairness without something more doesn't necessarily make it discrimination. And so I think there is a real misunderstanding about what actually is discrimination and how difficult it is to prove.
Absolutely, and I think it has to be a protected characteristic to form discrimination. And I think working for a union, when you are when we advise our workers, you do often get that as an issue where if it's not a protected characteristic, unfortunately, it's unfair treatment. It doesn't count. But that's often workers do jump the gun and say, well, no, I think it's discrimination and I would like to make a claim, and it's having that understanding. So from your experience, how have you dealt with that?
Managing client expectations is sometimes quite hard, but by the time it gets to me, usually, there is some type of evidence or some type of claim already issued. But if it comes to me before a claim it is issued, I often say to clients, particularly claimants, that you might have a protected characteristic and you might have been treated differently, but that doesn't necessarily mean that it is discrimination. It has to be something more than that. So there are a number of different prohibited conduct claims, which are colloquially termed discrimination. So, for example, under Section 13 of the Equality Act 2010, that's direct discrimination. So you are treated less favourably than a hypothetical or a real comparator would have been because of the protected characteristic. And it's that because of that is usually the real difficulty for claimants to prove, because no one is going to go to tribunal and say, yes, I did that to you because you're a man, or yes, I did that to you because you're black, or whatever it might be. And getting the evidence of that is really difficult.
So how do you think employers deal with discrimination claims, and what can they do as soon as they receive a grievance around that? The reason I ask you this question is because I often find, from my experience of doing certain preliminary hearings in the tribunal, that when you get to a preliminary hearing, there's discrimination, there's information that the employer hasn't fully uncovered, and discrimination is one that they can't just strike out, or it has to be fully explored at a final hearing. So as a result of that, going back to my question, what do you think employers can do to make sure they deal with discrimination claims internally thoroughly, so it doesn't lead to a claim?
Prevention is definitely cheaper than the cure, because, as the listeners may or may not know, employment tribunals are cost-neutral jurisdictions. So employers, even if they defend successfully a discrimination claim, they will have expended probably thousands on defending the claim running it to tribunal, and there are very, very limited circumstances in which they can recover those costs back. And so trying to prevent it from getting to litigation stages is a top priority. And I think the difficulty when internal grievances are raised is that there is this defence mechanism that's sort of ingrained in humans just generally, that they have to, defend any suggestion that there's been discrimination, or that will lead to a finding of liability, and that it's not going to sort of stop the issue in the tracks. But I think communication with their employees is paramount, because 9 times out of 10 nobody wants to end up in the tribunal. They just want the situation to stop. And so you might do the investigation early, transparently, with communication, and it might be just as simple as saying to the employee, what's your desired outcome? And it might be that they want to move to a different department, or they want to work less days, they don't want to work the shift with the certain individual. And just by asking that question and putting those things in place could prevent, a £20,000 claim going to tribunal.
That's really interesting. And I think sometimes asking that question, the desired outcome one, can actually lead to, when it does reach to a tribunal, it does help employers show that they've done each and everything to mitigate the risks, or to mitigate the concerns that the claimant has raised in the matter. But with discrimination, it's one of the areas where a lot of employees do raise, because with unfair dismissal, you need 2 years of service. Discrimination is one that employers often have to deal with, because under 2 years of service, if there's a probation, if anything goes wrong, they end contract, that's a tit for tat kind of situation. So what would you say about that?
It is 9 times out of 10 the only sort of mechanism for a claimant who feels aggrieved regarding a dismissal to have their grievance heard by a tribunal. As you say, ordinary unfair dismissals, they wouldn't have the requisite service. So there is always going to be that type of risk. But if they're dealing with it early on, carrying out the investigation, speaking to the appropriate people, documenting it, then they're creating the paper trail for the defence if it gets to that stage. And sometimes, again, it's just coming back to the question as to, asking the individual, what is it that you want from this? And I don't necessarily advocate for making commercial settlement decisions, but sometimes, they might just want their notice period and they've got another job to go on to. And it wouldn't be, out of the realms of reasonable just to give them the notice period and say goodbye. In fact, it probably would be a very commercially sensible decision to make rather than let the issue fester. The difficulty in the Employment Tribunal with discrimination cases is that there is a precedential case law that says they should be very slow to strike out discrimination cases because there is a public interest in having them adjudicated in public. And so unless there is very cogent evidence that the individual is lying or is being inconsistent in the way that they put the case, they're going to have to defend it. So trying to prevent that situation, which might cost them, I don't know, a week's notice, a month's notice, a couple of grand, to alleviate the issue rather than spending, 20, 30, maybe more thousand on legal fees defending the case. And I think it comes back to the communication matter, that communicating and being transparent and trying to dilute and diffuse the situation. And I think sometimes employers go all guns blazing, you're lying, you're this or whatever, and all that does is add fuel to the fire.
So I think what you're trying to say is dialogue is so important, and if early dialogue takes place, it does prevent. If it's predictable, it's preventable. So hopefully,
Absolutely.
That's not that's for employers, but also for employees. Over the years of your experience of advocating in employment law, have you seen workplace issues get better or worse when it comes to discrimination? I do know that there's a lot more development around beliefs in discrimination, and I think as a society, as time goes on, discrimination is one that just evolves because we are human beings. It's what we believe. There's certain areas that keep evolving. I know there's been an important case law that's come out about gender critical beliefs. So looking at it from a workplace perspective, do you think things are getting better or worse?
I think with regards to discrimination, just generally, it's one of those areas that ebbs and flows. It has something that happens, whether it be a case or a piece of legislation, that then creates this period of equality, and then something else happens that retracts on all that. So the very recent case with regards to same-sex single space is a fine example. We were moving in a direction where the Equality Act gave protection to those with gender reassignment protected characteristics, and then we have the Scottish workers women's
case.
The name escapes me, that then sort of backtracked on all that legislation. Looking at it on paper, of course, it's much more nuanced than that, but I don't think we are anywhere near being in a position where I could say that it's getting better.
And if I can add, I don't know if we will, because it's such an area that's just shaped by our beliefs and our perspective, and as society goes on, things always change, and I guess that's what makes employment law really interesting to practice in.
And that's generally why some discrimination cases are successful. There is a mismatch in values and beliefs. And there are sometimes these competed protected characteristics that the law will find in one way or the other. And I don't necessarily think as humans those values, beliefs and opinions are ever going to change. As you say, they will just evolve. So the issues will be there all the time. The context around that may just be different.
What would you say are the major challenges in terms of employment law today? I do know that there's going to be an employment law bill proposing a lot of changes. But in terms of, is there anything else that you would like to add to any of that?
I think the thing with employment law is it's always changing. And for employers, that's difficult to grasp because you get used to working in one particular way and you put all your policies and your procedures in place so that you're carrying out your obligations, and then something happens and it changes. The Employment Rights Bill is a fine example of that. Flexible working, another fine example of that that's recently been implemented last year. So that creates difficulties for employers, that there is always this ever-changing process of evolving and adaptations and sort of manoeuvring to fit with that changing landscape. But in terms of looking at it from an employee's perspective, that also creates difficulties because when things are changing, it's hard to know, well, what is the right piece of case law at this particular time, and what are my rights if they keep changing. And I think in terms of from a litigation perspective, the employment legislation has become so voluminous that it's almost impossible for an individual worker or employee to understand every single right that they have. They can, of course, Google it. Understanding and interpreting some of that legislation is difficult for some of the most intelligent employment judges of our time, and some lawyers can't agree on what some of that legislation means. So an individual layperson understanding that and asserting that right to an employer is also going to be difficult. From sort of recent experience, and I've done quite a lot of cases against litigants in person, they are on the rise, particularly recently, they are expected to know the legal tests behind the case that they are bringing. And I think it's quite evident that a lot of them don't look or try and understand the legislation for the cause of action they're bringing. So, for example, Section 26 claim under the Equality Act is a claim of harassment. It doesn't have the necessary everyday meaning to it in an employment context. And there is a misunderstanding. So they'll bring an harassment claim because they feel like they've been harassed. And they haven't looked at Section 26 of the Equality Act 2010 to even start beginning to see whether the facts of their case match the test in Section 26. And that's not a criticism of them because they're not lawyers, but there is an expectation from an employment judge that they will have at least done that little step.
It's understandable though, because if you are coming forward to an employment tribunal and choosing to represent yourself, there should be some expectation on you to represent and follow the law, have some understanding of the law to be able to do the representation justice. Obviously looking at the overriding objective, the court's time, the resources. But in those situations when claimants are representing themselves and they don't have all that knowledge and it's hard to interpret that law, what would you recommend they do? Can you signpost them to any, or do you know of any processes or any quick guides that they can reach out to?
It's difficult in terms of what they can do, but I think if they can get advice, you know, whether it's through some of the charities, so Advocate, Free Representation Unit, I think they assess claims before they advise, or unions, if they're a member, then they should certainly take the time to do that. Alternatively, good old Google. Just looking at and generally speaking, a lot of litigants in person have a general idea of what they think might have happened, but they don't go to the extent of actually sort of researching it, I would recommend to a person in that situation that if they are bringing a claim, that they include the factual narrative of what happened. And the reason that I say that is if you include the facts of the case, the law can be added at a later stage. Relabeling is a term frequently used by tribunals, and what that means is they can be much better assisted either by the respondent or the employment judge to attach a legal label to the facts that they've pleaded, so the story that they've pleaded about what happens. Whereas if they plead a story and plead a specific cause of action, they become a bit restricted in that sense. But yeah, good old research, nothing above that.
So I take 2 points from what you've just shared there, Chelsea, is the importance of having the right advice early on. So as a trade union, if you have trade union membership and you have that support, they can guide you through the grievance process or the disciplinary process where you're raising these concerns. So you do get a flavour of where your claim's going. Second, you can always go out to these charitable organisations but also get legal advice as well. And often I think it's missed because people do have like covers through their home insurance for legal insurance, but they don't realise that. And as a trade union, we often do ask that question. So do you have cover? If you do, that might actually help you rather than going all the way yourself, because that can complicate matters. And I think there's an important point as advocates and as a practitioner, I'm sure you'd agree, that never run your own case because you're so emotionally invested that you can lose objectivity, and it's always beneficial to have that support.
You can, and I think it is certainly an investment to those who really genuinely believe that they have a good case to have an opinion on that case very early on. And the reason that will be good is because, one, they will be pointed in the right direction in terms of causes of action, but two, they will also be given a realistic understanding of what that claim is likely worth and whether it is worth pursuing. There is a misconception that employment claims are quite valuable. They aren't. The ones that you hear about in the media are exceptional cases and not the run-of-the-mill everyday discrimination cases. And I think the median award for a disability discrimination case is roughly about 12 grand. So they're not very valuable claims. And I think having that sort of expectation set out very early on by paying for advice, if that's the only option, is very, very good and reasonable steps to take.
Thank you. Moving on to the time, otherwise known as jurisdiction in legal terminology. That's always a hot topic in employment law, and it's often something that workers don't fully appreciate or understand until it has lapsed. So what would you like to share about that for our viewers and workers out there?
Time limits, you would think, would be one of the most simple tests to establish in any type of litigation. Other jurisdictions have got it much easier in terms of, they have so long to bring a claim and that's it done. In the Employment Tribunal, it's a little bit different. Depending on the type of claim you are bringing will depend on the test for extending that time. So the majority of claims have a 3-month minus 1 day time limit. And the reason why it's minus 1 day is because the cut-off period is 12 a.m. And so that means that you need to bring it the day before, because otherwise it's out of time unless you're sort of on the computer at midnight. But with regards to bringing a claim in the Employment Tribunal, there are some very rare exceptions, but it is usually mandatory to issue a CAS certificate, which is a conciliation service. And you have to go to ACAS and start the conciliation process, which now runs for 6 weeks. You then get a certificate at the end, which gives you a ACAS certificate number, which you have to put on your claim form, otherwise the claim form will be rejected. And when you're talking about time limits, if you haven't done ACAS, there are obviously grounds for that claim never getting off the ground. And 2, if you don't put the ACAS certificate number in the claim form and you're close to a time limit, you risk missing that time limit. In terms of the tests for extending time, there are 2 different tests. So if there is something that has happened, and we'll come on to sort of the difficulties with time limits in a minute, but if you are bringing an unfair dismissal claim, the tribunal can only extend time if it wasn't reasonably practicable to bring a claim in time. That is a very, very steep hurdle, usually some type of physical limitation that you can't get to a computer or submit a claim because, you're in a coma or you're in hospital or something quite, severe that is preventing you from submitting that claim is required for that test. In discrimination claims, tribunal can extend time if it's just and equitable, and that takes into account a much wider range of situations. So things such as a lack of knowledge of the time limits, a lack of knowledge in the facts that amount to a claim, receiving wrong advice or negligent advice, or proceeding with internal procedures before bringing a claim. So carrying out and seeing through to the end a grievance or a disciplinary or whatever the process might be. But they are a last resort. Bringing a claim in time is really, really important. And this is what makes it so difficult in the Employment Tribunal, because 9 times out of 10, you're not just complaining about one scenario or one incident. There are usually a number of incidents over a period of time. And there is this misconception that the last act will make every other act in time. That can be the case, but not always the case. To be a continuing course of conduct, so that every act and the last act being the act in time, there has to be some common personality between them. So if it's the same perpetrator, if it's part of the same process, or the nature of the complaint is the same. But sometimes you have direct discrimination, and then you've got a failure to implement reasonable adjustments, and then you've got a victimisation claim. Well, they are 3 prohibited conduct claims, very different natures, and you will have claimants say, well, the last Victimisation Act brings all those in time. Not necessarily the case. And so really understanding what it is that you're arguing and making sure that you keep an eye on time limits and issuing protectively if that is something that you want to consider, so that the time stops and you protect your position. And it might be that you say to the tribunal, look, I want to now proceed with the internal processes and stay the claim. But they are really, really, really important, and you can lose a very meritorious claim because it's out of time.
I think that's really important, and I would like to share for our workers, is that whilst internal processes are happening, you do not lose sight of this time jurisdiction issue, because from the date of the act, if you let sometimes grievances can take ages because there's a number of factors at work that influence the outcome when the outcome's delivered or reached. And it's really important to be aware of the 3 months minus 1 day rule. And you also have ACAS. ACAS plays a major part, but it stops the clock. However, there is a bit of issue with ACAS currently because unfortunately they're really badly backlogged as well. Now, it's really important to, again, as soon as you get the certificate, to make a claim within that 1 month time limit. Otherwise, again, you risk the claim being out of time. So again, that's just a reminder for our workers out there who are litigants and claimants and litigants who are making the claims themselves. Chelsea, in terms of, we spoke about time limits, and they are quite short given where the tribunal is at the moment, given how there's a big backlog with pandemic and with the public bodies such as ACAS. Do you think we should see some sort of an extension on the time limits in terms of the changes in law, or do you think that wouldn't actually help the situation?
I'm torn on this topic because the tribunal was created so that there was quick, efficient access to justice for workers, so that these didn't lay dormant for however long and then crop up, so that there is some finality to the employment situation. So I agree that there should be a short time limit, because these claims are often a he said, she said situation. And as time goes on, memories fade. Now, I say that in the full knowledge that when a claim is issued, it can take 2 to 3 years before it is heard. And so there is a situation that we are currently in where the tribunals are potentially not fit for purpose, and, not through any individual's fault. They are backlogged, they understaffed, etc., and all the cost budgeting issues that most public services have. So I don't necessarily agree that it should be extended substantially. I think that there is a potential that it could be increased slightly, but the reality is, I think 3 months is a good time limit, and it really focuses the mind on whether you are going to or not claim. Whereas if you've got longer, you toy with yourself and much more thinking, and of course it opens up much more claims.
Again, on the topic of developments in the law, we've got the government proposing day one rights for unfair dismissal claims. What do you have to share about that, Chelsea?
The concept is a good idea. I think everyone should have some type of protection. The workability of day one rights in the long term, I think, is problematic. And the reason for that is this: where an employer is faced with having to analyse the fairness of a dismissal from day one, so they have to go through the procedure, the consultation, the investigation, the hearing, and all that comes with analysing reasons for dismissal. And that costs time, it costs money, and it potentially creates this anxiety about, if the procedure is unfair, the dismissal is unfair, even though the substantive reason might be fair. And it creates this rigidity and inflexibility for employers, in the sense of they will just stop employing. And we are heading into an era where you now have employees that are artificially intelligent. And so I don't necessarily think that it will have the purpose that the government have intended it to have. I think it will lead to a decline in employment, because employers won't want to take on that risk when there are other means and ways around it, particularly in this day and age.
What do you think might be more effective? Instead of 2 years is a very long time, and it can lead to certain employers also exploiting it. Yes, there's also the risk of employees, they will, there's a terminology that's often used, which is malingerers. They'll come, join, then just put a claim in. So what would be the middle ground? From reading up about it, some people propose maybe a 1 year, reducing the length of that unfair dismissal right claim. So what would you say about that?
I think the House of Lords have got it spot on, in the sense of a 6-month service requirement before being able to bring a claim. 6 months gives the employer sufficient time to really know whether the individual is going to be good at the job or not. I mean, if you haven't picked up, and obviously this is generally speaking, there will be different careers and professional roles that may require a little bit longer, but 6 months you would have a general understanding of whether that individual is a good fit for that role or not. And it really sort of puts the time into perspective, in the sense of it requires the employer to do all they can in that period of time to see whether they are or not a good fit for that role. So it's not too long so that people are left without the protection, but it's also not too short that it becomes unworkable.
Chelsea, without sharing any confidential details, we would like to know if there was a memorable case that you would like to share with our viewers and listeners today, and what has made it memorable for you, and are there any lessons learned in terms of like for the employee perhaps, or even for you as a practitioner, so that you can share and with our listeners?
I knew exactly the case that I was going to refer to, and I think I take all my cases to heart, and I hate losing any case. Even if I know it's a losing case, I still hate losing. But I had a case quite early on into my career, and it was one of those cases where I thought it was nailed on. I thought it was going to be successful. The evidence was there, it was in black and white, in writing, and there was just no way we could lose this case. I was for the claimant. Long story short, he was working in a firm and was offered a partnership. So he would be transferring from an employee to a self-employed position. And he had indicated that he wanted to agree terms before that change happened. And the terms were not agreed, but they removed him from the payroll and put him into this position. And he'd not seen accounts and things such as that you'd want to see if you were becoming sort of a partnership type situation. And one of the terms that weren't agreed was how much he was going to be paid by this partnership. And this went on for about 18 months, where he's asking them, I need these terms to be agreed. I'm in a risky position here. I don't know what's going on. I don't know how much I'm getting paid. And he had emailed them and said that he had a meeting with a mortgage advisor and he needed to know how much he was getting paid. At tribunal, in his own witness statement, offered to the tribunal, that wasn't actually correct, but I was desperate to get these terms agreed, and so I made a little white lie. The tribunal dismissed every single claim on the basis he was uncredible because he admitted to lying in writing. To me, I was shooketh because I just thought that's completely overlooking the reason why he'd done that. But credibility in court is the most important thing. And in any situation, being open, transparent and honest is the only way to go. And clearly in that situation, that was to his detriment. He lost, a very valuable claim for one silly, quite trivial in my view, mistake. And that has stuck with me for years now, because if you'd have asked me, I would have put my house on the line that we were going to be successful in that case, and we weren't.
That's really interesting. And again, taking the lesson that we can take from that and share with our viewers is that how important credibility is for the tribunals, as you mentioned. It's often, from the cases that I, in my experience, have seen that as well, it's the witness statements and the evidence given at tribunal can make or break that case. On face, it seems like everything's going really well, but as soon as a witness, if one answer, like the credibility, if that's attacked and that's diminished, it can really influence the outcome you get. There are cases from my memory as well, where you've gone in, everything's like absolutely okay, and you're shocked by the actual outcome of that case, and it's because it's how the witnesses actually stand on the day. As advocates, we all know that being in that position as a witness, giving evidence, it's never easy, and you never want to be called as a witness. But often when people workers are submitting claims in, and are representing themselves, they forget that, yes, they are doing that element, but they will also be asked to give evidence on that matter. And the importance of having everything checked and correct in your witness statement. Because often people forget, and I think, again, that's another point about litigants in persons, is that they think a witness statement, you just put about a story, but it's everything that's around that situation, and you have to be thorough, because if something comes in to light during evidence, you will be asked, why didn't you share that before? So it's the importance of credibility and the evidence you give.
Absolutely. And I think with regards to evidence and litigants in person, this is quite a big issue in the employment tribunals, because they don't know how to draft a witness statement. They're not, legally qualified. And just in terms of a little bit of advice, because when a tribunal is assessing credibility, they are looking for, on balance, so more likely than not, which version of events is true. And generally speaking, the more specific you are about a specific situation, the more likely it is to be true, theoretically. But this is the way that the tribunals have to look at it, in the sense of they're listening to two people tell two different stories. Who do they believe more? The one that's giving very vague answers, or the one that says, on Monday, I was at the water fountain and Beyonce was on the radio and I was taking a drink of water and Michael came up behind me and slapped my bum. And the other guy was like, well, on Monday, I don't know, really. Yeah, I saw her about, but I didn't really speak to her. And that's how they're assessing credibility.
Yes, but it's equally tricky though, because most of these claims, when they get to tribunal, it's been 18 months and you do forget the account. You forget the minute details, such as Beyonce being on the radio and certain things like that. But it's the importance of having all that information there. And I guess it's about record keeping and making sure you...
Yeah. And this is... and I always say to clients that it's not a memory test, which is a little bit of an oxymoron, because sometimes it kind of is. Because if you don't recall certain details and you're bringing a claim, you're expected to remember those surrounding facts to the claim that you'll bring in. And I think this sort of feeds back into this 3 months minus 1 day time limit being quite short, because if you bring a claim early on, you're much more likely to remember those specific factual details. And so when you put that into your claim, you have a nice reminding prompt when it gets sort of 2 or 3 years down the line, when you're giving that evidence. But yeah, keeping records. If, as a lawyer, the rule is if it's not written down, it didn't happen.
So from your perspective, how much of a difference does it make to have be in a trade union and have trade union support?
I think it makes a massive difference, because when you are going through any type of employment grievance, it can feel very lonely. Because if it's a disciplinary, there are usually processes in place that mean that you can't speak to some of your colleagues, so you feel quite isolated. And having a trade union representative in those situations is very, very important, because sometimes that's your way of venting and sort of dealing with that situation, one. But two, they probably know your rights more than you do, and so they can advise you as to those, and forearmed is forewarned. And if you know what your rights are and you can assert those rights to your employer, they are less likely to breach them, firstly. But secondly, they have the experience, knowledge and understanding of what works pragmatically with the different employers, so that you are in a protected position, in the sense of, ultimately, if you are facing losing your job, the trade union's aim will be to keep your role. And they usually have first-hand experience in the types of things they can say or do that will reach that aim. But also, they usually then have some understanding if it is a situation where you are going to have to bring a claim in the Employment Tribunal, that they can advise you on what types of claim you have. And that's really important because, as we spoke about before, knowing your claim and understanding the legal tests involved is a complex situation and task if you don't have a law degree. It's sometimes difficult when you do have a law degree. So having that support is invaluable. And you can really tell the difference sometimes between those that have had support and good support and those that haven't, because they understand the process of litigation. It's overwhelming, it's time consuming, it's anxiety invoking, you're going to give evidence, you're going to be cross-examined. And sometimes litigants in person that haven't had that assistance or support have no idea what they're walking into when they come to a tribunal. And so even just things such as that, understanding the procedures, being informed of the procedures, they can offer that kind of advice and assistance. So yeah, I think it's really, really valuable.
Finally, what advice would you give to our listeners about when they are facing this situation, either with workplace issues or bringing a claim in the tribunal?
I think that the first bit of advice is to really understand the situation. And it might be that they're facing a disciplinary, or they've raised a grievance, or they feel like they've been sexually harassed, or whatever it might be. But I think they need to take some time and really understand what they say is going on and document it. Keep a diary, write it down. If it's not written down, it didn't happen. And sometimes that just helps sort of vent the situation, but it's also a very good prompt to come back to, because it's a contemporaneous note of what you say happened at that particular time. But also have some kind of understanding of how you want the matter to be resolved. So if it's a workplace grievance or workplace process, tell your employer or tell your employee, whichever way round it might be, how you want that outcome to conclude. And sometimes just saying that can lead to the outcome that both parties want. Nobody wants to end up in tribunal. But also really understand the realities of bringing a tribunal claim. It's not easy. It's not easy being a witness. It's not easy being cross-examined. It's not a short process. It's long. It's time-consuming. It's overwhelming. It's daunting. And you are going to be, regardless of which side you're on, you're going to be put through your paces by the representative of the other side, because that's their job. And you are going to feel like you're challenged, like your personality, your judgment, your character is being questioned. And the reality is that it is. And so really understanding what the process is and what it will take and how long it will take sometimes gives you that sort of reality check to, do I really want to do this for this? Or is it really worth defending this for this?
Yes, just on that, I think going back to what we talked about, having the right support matters, because you've said it's not an easy process. It can be daunting. It's traumatizing. Your judgment is questioned. Your personality is questioned. Your character and your personality, like you as a person, is being put forward, and that's all under scrutiny. And it's really important to then, if you are representing yourself, how difficult that is to then give evidence and then go back to cross-examining the other party. It's not an easy process, and I'm sure as practitioners we wouldn't find that easy, so let alone claimants who are representing themselves, litigants in person. Just as a practitioner with lots of experience in this area of law, what's one thing you feel or you wish everybody understood about employment law?
That it's not there as a finger-pointing mechanism. It's not there to create claims. it's there to ensure that people can go to work safely, happy and protected, and that benefits both the employer and the employee, because some of those legislation, regulations are there to protect the health of a worker, and so by flaunting and disregarding those, you're putting your workforce at jeopardy, and if your employees don't come to work, your business can't run. And I think that there is this, on both sides of the coin, this misunderstanding that the employment legislation is there to have checks and balances and create this mechanism for claims. And that is not the purpose of employment law. The purpose of employment law is to create a booming economy for all. And so I wish everybody understood that.
Well, thank you, Chelsea, for your time today and for sharing all your experience and all the advice for our listeners. And hopefully, there's many takes from that we can, share and keep going and learn from. Thank you.
Absolutely. Thank you for having me.